Hi, my name is Harp Khukh. I'm grateful for the opportunity to speak to you. I'm a lawyer at CORESTONE Law. We practice construction litigation. A large portion of my clients are engineering companies, both big and small. Our firm has been legal counsel to the Ontario Society of Professional Engineers since 2014, which is why I'm being asked to speak. We have several courses with OSPI, and when we were asked to do this seminar, we were trying to decide which topic would be suited best. One of the more popular courses that we have is on contracts. Also, when the pandemic hit, I found that a lot of my practice involved reviewing, revising, advising on contracts. People feared economic recession, and due diligence was done when taking on projects or with projects already going on. The OSPI course on contracts is about 3 hours long, but I'll do my best to squeeze as much information as I can into this small seminar. The goal will be not to provide an exhaustive seminar, but just to key you in on some of the key clauses and terms that a contract should have. So this is our information. We are working remotely, but our office is in downtown Toronto. The best way to get a hold of me is by email right now, and sometimes lawyers are hard to get a hold of, so I have my assistant's email as well. So if you are so inclined to contact us, please do. I think it's only appropriate to have a legal seminar with some type of legal implications. So here's our disclaimer. We do our best to provide the best information possible, the most accurate information, but when it comes to contracts or any type of legal situation, it's never a one-size-fits-all. There's always specifics that have to be considered. So, you know, this course isn't a comprehensive discussion. You still want to seek legal advice from your lawyer. Contracts is generally the cornerstone of your practice, so it's an investment that's well worth the money. So we'll just start off in this discussion. We're talking mostly, we're talking exclusively about written contracts. In contracts law generally, there's no requirement that an agreement be in writing or signed. So a verbal contract is enforceable so long as that contract is, the key terms are discussed. Like an example would be, let's say an engineer is asked to do a site review on a very isolated issue. The engineer, discusses the payment with the client, says it's $500 per visit. The engineer attends and does the work and provides whatever opinion to the client. Even though there's nothing written there, it's still a contract. There's still the offer acceptance and a discussion of pay, and that's enforceable. The verbal contract has implied terms, which basically just means terms that would be implied by law. So for example, if an engineer is providing services under a verbal contract, it has to be of a good workmanship. At the same time, there's an understanding that the engineer is going to be paid for his work. Those are implied terms that are always there. The benefit of a written agreement is, though, that you have an arrangement between the parties and it's known to both of the parties. So if a dispute does arise and there's any type of legal intervention, there's a benefit of a written contract with the intention that's written. Even if it is if a court does accept an oral contract, the terms and conditions are always up in the air, and there's a lot more room for uncertainty. With verbal contracts, you would have to go and prove what the intention of the parties were. Was it through emails, through affidavits, and I'm sure you can see the complications with that. So these are the two purposes generally that I find, why we want to use contracts. I've already mentioned the expectation of the parties. So there's an understanding of what's going to be provided and what's going to be done. At the same time, it's a great opportunity to minimize and help prevent problems down the road. And we'll get into that. So just talking about risk, we need to look at two concepts. We're going to be talking about contract liability, but I think anytime we're talking about any type of liability, I always want to bring engineers' attention to professional negligence, because it is very important. Generally, the biggest complaint that comes, other than an unpaid invoice from an engineer's end, So we have contract liability and professional negligence. So with professional negligence, think of it this way. So professional negligence, this is the legal test that's there. With a contract, you're contracting with a party, and there's always an obligation there. With professional negligence, it actually can go beyond contracted parties. So you can be liable to third parties that you had no dealing with. So a classical example is you provide engineering services, let's say structural engineering on a new build for a homeowner. The homeowner, accepts the services, the home gets built, years later sells that the home to a subsequent purchaser. If somehow the services were deficient, that subsequent purchaser who had no relation with the engineer would still be able to pursue if there was professional negligence in the work. And the test, here the engineer owed the claimant a duty of care. I don't think it's arguable that if you provide structural engineering services on a property that you can be liable to subsequent purchasers. The engineer's conduct breached the duty. That comes to the concept of standard of care, which we will discuss in one of the clauses later. And the third is there must have been some type of injury or damages. So here, let's say if it's a foundation issue caused by the services, then if that foundation issue had to be corrected, those would be those damages. So contract liability, in the case of contract liability, contracts contain various terms that impose contractual obligations and standards on a profession. If a contract fails to express the same, so if the contract, and this is we'll have a bit of a discussion about how long a contract needs to be, but what I'm trying to say here, if a contract fails to express a term, our legal system will imply certain obligations on the parties. And whether it's contracted or implied, if it's a dispute between a client and an engineer, then contract or breach of contract is always a risk. So here's the main portion of our discussion, and these are the important terms. At least these are terms that generally when a client comes to me with a contract, I want to make sure that they have in there. This is not an exhaustive list. For those engineers that are in construction, they're familiar with CCDC contracts, and you'll know those are 30-page contracts, 40-page contracts that have a lot of clauses. I've seen contracts that are 1 pages to 100 and 200 pages. If you wanted a very comprehensive contract that contemplated everything, you would be surely over 100 pages. And on maybe a major project, a P3 project for the government, that may be warranted. But other than that, you might just scare off your clients. So you got to strike that balance in your practice to know what key terms need to be there to protect yourself, and at the same time, not scare the client. At the same time, if you're in a position where you have to accept a contract, you want to make sure that these contracts are there and considered, for things that should be added or to protect yourself. So we'll just start off with the first one is contract documents. So this is generally when I'm looking at a contract for a client for a project, this would be probably one of the first terms I look at because it lists the contracts. The documents. Maybe a contract, it may be a specification, it may be a design, it may be a report from another engineer, for example, a soils report, it may be an addendum to the clauses. Sometimes if you're a subcontractor, it may be the main contract and so on. And you want to make sure that whatever contract you're executing, that all the contracts that are within your mandate and that you should be aware of and adhere to are included in this. And the scope of services, one of the most important sections, in my opinion, for any contract. I've written articles on professional liability, and I usually list carefully define the scope of services in written contracts as a number one way to avoid negligence claims. And number two is understanding your scope of services and how and when they are fulfilled. One of the most common disputes that arise, are generally misunderstandings with the scope of services. Need to clarify the understanding between the parties on what the engineer is exactly going to be providing it and what the fee structure is going to include, what services. And it's especially important because if an engineer does work that goes beyond its scope, they're going to want to be compensated for extras. So when you list the scope, you want to make sure that that's considered. And if additional work is required, that you'd be able to be paid for that. I think, with engineering, classical engineering services, when we're looking at civil, the example that always comes to mind is design and review. Generally, if you design something, you're responsible for review. But, one too many times I've seen a contract where an engineer designs, but the owner, the client, may not want an exhaustive review mandate. And in that situation, I think the engineer needs to list that down and put a price for what a review is going to cost. At the same time, they want to list that they're not going to be responsible for the construction and the review to implement the design. So it's good to be as detailed as possible here. So the next one is the standard of care. We touched upon this right now for professional liability. So this is ultimately the threshold that engineering service are judged upon. This clause generally highlights the standard and quality of the services, the test. So the general test in law is if a professional with a similar experience and skill would have come to a similar conclusion and provided similar services, then possibly no liability will be found. We're always looking at from the perspective of what a reasonable engineer would do. The standard differs from profession to profession, but there are general legal concepts that have arisen over the years that tell us what the standard is. This is it is a concept that's not easily understood, but we can say, we can make these following statements that tell us what the standard is: that a professional is held to a higher standard than a layperson. The standard is of a professional with the average professional competency. A professional should not be compared to the most skilled person in that field. A professional should not be held to a standard of perfection. An error or mistake does not result in liability if others in the field would have acted in the same manner. The standard may increase if a professional represents special skills or expertise in the contract or other communications. So a standard of care contract clause, in my opinion, doesn't need to be there from an engineer's perspective because that is already imposed on you. It's implied on you that you're going to work to the standard that's required in the industry during that particular time, during that geographical area, because different areas may have different standards. However, you see, many clients that do want to impose this, and if they are imposing a clause for standard of care, we want to make sure that it is referring to a reasonable engineer and not increasing the culpability of the engineer by using words like best services, expert in the field, because then, even though you may have met the standard of care required for your services, you may be imposed to a higher standard. Next one is a timing clause. And, in the world of construction, timing is always important. This clause states that the services must be provided in a certain amount of time. Let's say, example, 6 weeks for a project. This is a clause that, again, engineers generally want to avoid the timing clause because it ultimately imposes an obligation on the engineer. And if it can't be avoided and it has to be included, the engineer needs to make sure that there are other clauses in that contract that we will look at. A delay clause that allows changes to the schedule. I've had to give an example of a situation. For example, let's say you're doing structural engineering and you require a soils engineering report to finalize your design, and the client is responsible for getting that. And even though you have a 6-week schedule, the report comes in 4 weeks late. Again, if you're providing a design for something like a bank or a commercial business where, a month of delay could mean major money, you want to make sure that the timeline is either adhered to, and when it's not adhered to, that in real time, that notices, letters, emails are provided that there's going to be an extension required on the schedule. Sometimes you'll hear the term time is of the essence, timing is of the essence, and be alive to those words when you look at a contract, because it makes this concept of timing a material term, and delay is a very significant set of damages that you want to always be aware of within the engineering field. So just continuing from the timing clause, we want a delay clause. We want to make sure that there is a mechanism put into place that allows an engineer to change the schedule or to request the schedule be changed. The soils engineer's example, is great. There's change orders that get used in construction a lot. If there is no formal change order, there should be notice. At the same time, delay also can lead into a cost consequence for a client. And you also want to make sure that if the delay isn't on your end and it's on the owner or somebody else's end, that you can be compensated for whatever that delay is. So this clause may also go into that. Billing and payment. We want to make sure that with billing and payment, this is one of the more important clauses that I reviewed during the pandemic. And a lot of my clients wanted to focus and make sure their contracts were very strict when it came to termination. And I think you have to look at 3 key clauses when you're looking at billing and payment. First is a term period of when accounts and invoices are going to be paid. So the common ones are 7, 15, and 30, or payment on receipt. So, I'm a fan of more accelerated schedules, but at the same time, we have to have a balance with the client. So payment immediate may not be possible. At the same time, we have a Construction Lien Act that was amended over 2018 and 2019. So there are a prompt payment regime that's in place that may be applicable. We wrote a pretty comprehensive article and put in a chart in, I believe it was a summer issue of OSPI's Voice, which you can look at, that kind of that hits upon that. We've also done courses last year, not this year, but hopefully next year, on the changes to the Construction Lien Act, which focuses mostly on this prompt payment and adjudication regime, which, if you're interested, may be worthwhile if construction is one of your main areas of business. So if an account isn't paid, we want to also, so the first one was the term payment. The second one is to have some type of interest component as a bargaining chip against the client. I've seen clients have anywhere up to 1.5% interest per month, so 18% yearly, which is something that, if a client doesn't pay an invoice or a dispute arises, there is a bargaining chip that can be given off, if a payment is made. And this brings us to the important, the discussion at least I've had with the pandemic is termination for non-payment. And so when the pandemic hit and clients were looking at what resources they had to allocate to different projects, they were, first looking at a lot of their unpaid accounts. And they were trying to assess, can we continue with the project if it's in arrears? And although it, You would think that non-payment of a contract would allow you to stop services or suspend services. When you're dealing with something like construction, where there's a delay implication of a project being slowed down, that's not always the case. So the case law isn't really clear. So what you really want to make sure is that you have a termination clause, a non-payment clause that says that you can either suspend for non-payment or you can terminate a contract for non-payment. And there definitely will be an asset. So if you don't already have that, you may want to include that in future projects. So change to the contract price, extras, we've already gone over this in the delay. I think, there needs to be a mechanism in play that generally says that the contract can be changed between the parties. If there's an agreement from both parties at the same time, there should be extras contemplated in there for unforeseen conditions, for instructions on site that happen. There may be a change order procedure, an agreement procedure put in place, but I think having a clause like that would at least allow the possibility that if you end up providing more services than were originally agreed to, that there's an intention there that you'd be paid for those. So force majeure is the second thing that I think when the pandemic hit, a lot of clients looked at. And these are the clauses that allow you to terminate or to suspend work in certain situations. And you'll see them in a lot of contracts. And, they can include, flood, earthquakes, the whole gambit, war. And originally when the pandemic did hit, clients wanted to look and see if the pandemic or the emergency orders fit within those clauses. There's some heavy litigation going on these issues in North America on whether force majeure clause would apply to the pandemic. But I think going forward, you're going to see a lot of the force majeure clauses with the language, pandemic, emergency order, COVID-19, virus, or just enough language that a situation like this, should it occur again, would fall within this. And it gives either party the possibility of terminating a contract if they're unable to financially complete it due to one of these issues. So limitation of liability clauses, probably one of the most important clauses that get put into any contract. Also one of the most litigated clauses and argued about clauses that are in contracts. The goal of a limitation of liability clause is to put a limit to the damages that do arise from this transaction that you have with your client. And specifically, you'll see a lot of contracts that'll limit fees to the insurance. They would say that any liability that should arise is going to be to the coverage that is provided by the professional liability insurance of the engineer. At the same time, you also see many clauses that limit it to fees. So, if $100,000 of engineering fees are paid, you'll limit the liability to the upper limit of the fees. For limitation of liability clauses, I think there needs to be an understanding of the parties. And if there is a limitation of liability clause, there has to be a discussion between the parties to make sure there's an understanding and an agreement on this point. At the same time, just an extension, you also look at the type of damages you have, direct damages, you have indirect, loss of profit, special, punitive, consequential. So there's a bunch of things that are considered, and you may want to, for example, we talked about the delay with the bank. You may want to limit some of those indirect, consequential, or loss of profit damages. If you're a corporation, you may want to limit the liability to the corporation and not the directors. So all things to consider. And now we have the Indemnification Clause. And this is a clause you see a lot. It's the clause about the hold harmless. And the main attempt is to transfer liability or responsibility from one party to the other if something should happen. And various obligations, for example, if your services resulted in some type of lawsuit for a client, they may want to be indemnified for their legal fees. They may want you to hire a lawyer. They may want to, so that's taking up your defense. So various considerations that have to be considered. I think when you're looking at indemnity clauses, it should be a two-way street so both parties get the advantage. At the same time, you really want to look at unfavorable indemnity clauses that make a party responsible irrespective of their proportion of culpability. So, let's say there's a delay on a project and you were 15% responsible for that delay in your actions. You want to make sure there's not a clause that now makes you completely responsible to do that 15%. So language is very important. Dispute resolution. So normally you see dispute resolution clauses all the time that mention arbitration and mediation. I would say still in my practice, when a problem does arise, everybody does want to go to classical litigation. So, if a problem arose in a contract, what are the three ways? I would say there's generally three ways to resolve it, which are court litigation, which is commencing a lawsuit, a defense, going to court. Then there's a mediation, which is you voluntarily get a mediator to discuss the issues between the parties and to mediate a settlement. This is non-binding. And then you have arbitration. Arbitration is like a court case, but you hire the arbitrator. So it's a private judge that listens to whatever the problem is on a very expedited basis and provides a determination, which can be binding. And I think with the pandemic and the courts being backlogged, we had an emergency order that was in place from March 16th to about September 14th, which slowed down quite a bit of the litigation and whatnot. So you're seeing arbitration and mediation being used a little bit more. So you want to make sure you have these clauses in the contract as well. At the same time, if you are doing construction services, the Construction Act on October 1st, 2019 had, the adjudication regime put in. So you want to be familiar with how issues are resolved within that framework. And that comes to the conclusion of this small seminar. Hopefully you got some important points, some things to look at when you're reviewing contracts, some things to include in your contracts. As I said earlier, this is just a general discussion. I think I've highlighted you to at least important concepts that you need to look at, but at the same time, please do get legal advice, do get a lawyer to review the clauses. Like I said, contracts, I think, obviously for any business is whether you want to call it the bedrock or the cornerstone, it's important to have good contracts in place. Thank you very much.